for just a little while as I get to talk about my favorite topics, compliance in the law. So today I have, and I can honestly say this, and I know I've said it before, but it's the truth. Um, I have a very good friend joining me on the podcast today. Not only is he a very good friend, he's an incredible attorney. He's just a tremendous human being because I've had an opportunity to watch how he engages with his clients who are facing some of the darkest days in their lives and the level of comfort and reassurance that he brings to them. So I don't want to, blow his head up too big, but he really is a super lawyer. And I know a lot of folks, they send off like $99 to these different magazines that publishes super lawyer. I'm actually for all the attorneys that I work with who I know are super lawyers, I'm gonna give them a gold star and I'm gonna put like super lawyer, and I'm just gonna give my own designation. So Ron Chapman's here with me today, joining me live. So excited to have you here, buddy. Incredible case that you just prevailed on. Full trial acquittal. I think it was 38 counts of an indictment against this physician.
Yep.
For those who are not familiar with this case, this is United States v. Lesley Pompy, who is a pain management anesthesiologist physician in the Eastern District of Michigan. Give us some background about who Dr. Pompey is, where he came from, how he, got to the point where he became a target, basically, of the federal government.
Yeah, and first, Sean, thanks again for having me. It's always a joy to be on your podcast. I consider you a great friend as well. I mean, it's such a benefit and a bonus that we get to have this friendship, and then you come in and testify in a case and do a wonderful job. Amazing working relationship and amazing friendship, and I appreciate it. So let's jump right into Lesley Pompey and how this whole thing started, because it's bizarre. Sean, that when we're looking at audits and when we're looking at, maybe OIG actions for suspension, they follow a playbook. But when we're dealing with indictments, the government doesn't follow that playbook. And that's an edge that you and I generally play up at trial quite well. And this one has the similar note to it. So back in 2016, actually a little bit before that, in 2015, there's this entity called the Monroe Area Narcotics Team. And they go by Mantis. They like to have these fun acronyms because it makes them sound cool. That's basically a state police task force that's been created to investigate sometimes doctors, but also traditional drug trafficking on the street. Well, there's a gentleman there who was there named Mark Moore. Now, mind you, this task force was new. The prior task force was actually disbanded because of some ethical violations related to seizing money and improperly using it. So there's already blood on their hands. It's kind of a dirty organization. But they decide that they want to land a big case right off the bat, and so they turn to the first doctor that they could find, Lesley Pompy. Now, during the course of the trial, there was no evidence introduced of any legitimate tip about this guy doing wrong. If you've got a pain management provider operating unlawfully in an area, you would think that the referring doctors would know what's up. This guy worked in a hospital building. You'd think that the people who work in the hospital building would be reporting him. You'd think there'd be patient reports or deaths or malpractice lawsuits. None of that, Sean. Absolutely.
And don't forget, you have peer review in the hospital. So if there's ever a concern, I mean, it's going to go before the peer review of that entity.
Yeah, they've got a mech, and if they think there's something wrong. So this guy rounded in the hospital, and he also had an office-based practice. Well, having none of that, they decided to create evidence, which is generally what the feds like to do when they don't have anything. And the way they decided to do that was send in an undercover. And this is where it gets really unique, Sean. They didn't send in a DEA agent. They didn't mic up a patient to see what treatment was like. They decided to go to Blue Cross Blue Shield and say, and I said this during closing, give us your sneakiest guy. Give us the guy who's able to do these Blue Cross undercover investigations, and we want him to wear a camera and go into this practice. So he goes into the practice, realizes that he needs a referral to get into the practice because Dr. Pompey is a specialist, and specialists like referrals, and insurance companies do as well. So he goes to another doctor, Dr. Robertson, and has Dr. Robertson fraudulently create and backdate a referral for pain management. Now, this is Blue Cross sanctioned by a state police law enforcement entity, falsely modifying medical records to induce Dr. Pompey into allowing this patient into his practice under the auspices of a legitimate pain management referral. So he gets into the practice. First couple of visits, no controlled substances prescribed. Dr. Pompey ordered an MRI, a CT scan, X-rays, the whole bang of tests. This guy was sneaky, and he created a whole bunch of excuses, insurance not covering it, for not getting the testing done. And ultimately, Dr. Pompey prescribed, I believe, maybe it was a month of 5 milligram Norco, which to a jury, they may be like, oh my gosh, opiate. But to you and I and every other pain management professional out there, that's not a high dose of anything. That's not the type of dose that's going to get you seriously hooked. So he decided to use that as a bridge. Of course, the undercover was negative on the next few urine drug screens. And Dr. Pompey continued to prescribe while trying to get the testing. And then the undercover operation ceased when they were pretty sure that this patient was going to be cut off. And I know this is long-winded, but this gets us to the final point. Once they got Dr. Pompey to prescribe to this patient 2 times, they ended the other undercover operation. They took no more investigative steps. And then they moved forward to a prosecutor.
So two prescriptions
Yep.
of 5 milligram of Norco for 30 days each and I'm repeating this because I want the listeners to hear this. I mean, we have about 175,000 downloads of these podcasts a month.
Yeah.
So I know people are listening and I want them to understand this.
Yeah.
2 months treating somebody for breakthrough pain, trying to keep them comfortable during a period of time where the physician is fighting, advocating on behalf of the patient who's complaining of whatever their symptomology is, whatever their
lower back
pain
pain
levels are, whatever it is, all of it, right?
Mm-hmm.
All the while, Blue Cross is denying the MRIs, the CT scans as not medically necessary. The patient's continuing to complain. What's the physician supposed to do? Tell them go home and take an Advil, take a Tylenol? I mean, is this not entrapment?
Well, I mean, this is the problem. So the only medical professional who advised Mantis, the law enforcement entity on this case, was a guy named Dr. Carl Christensen. He was there every step of the way and reviewed the medical records and the videos of the treatment after, and he said, this is treatment without a legitimate medical purpose. Now, here's a few things about Dr. Carl Christensen. First, he's 0 for 2 against me. Juries do not believe this guy. The last trial we had was a month-long trial against a guy named Dr. Osterling, who was like a Johns Hopkins trained physician, fantastic guy. Full acquittal after Christensen was on the stand for a couple of days. And obviously he loses this one. Guy's got no credibility. Second thing is he's an addiction medicine professional, not really a pain management doctor. And the reason he moved into addiction medicine, and I don't mean to shame him for this, but it's just something that is important to the facts. The reason he moved into addiction is because he was a former addict himself. He was abusing cocaine while he was a doctor and decided to go into addiction medicine treatment. And anybody who is in the addiction medicine field knows that people who are previously addicts sort of have to train their mind to have this really aggressive approach and view towards other people who take medications. And that's his view. So they get the most biased guy they can find. They get the sneakiest investigator they can find. And then they don't do anything else. That's it. They raid, they shut him down, and then, the rest is history.
So I think this is another area where we got to be very clear for the listeners. There is a significant difference between addiction counseling and pain management. They are not synonymous. I've had a lot of people make the misrepresentation or mistake in explaining that even though a physician is a pain management specialist and they are trying to keep patients away from, the Norcos, the oxycodones, the oxycontinins, whatever it may be, that's not addiction medicine. That's finding a way to break the cycle of potential addiction, right? it's not the same thing as addiction medicine. Is
Yeah.
that's a fair
No,
classification?
You're absolutely right. So Dr. Pompey is a triple board certified pain management, addiction medicine, and anesthesiologist physician, trained at the Cleveland Clinic. Fantastic. Dr. Christensen doesn't have those board certifications, only trained in addiction medicine and opined on his care. So after the search warrant, then they get a hold of, you know, the worst of the worst files, the most complicated patients, the most difficult problems. They review those, they cherry pick, and then the state ultimately refuses the case, sells it to the federal government, and the feds decide to indict, and they indict on these most problematic files, right? After the trial, I was talking to somebody, and they said, you know, I would never want to be judged on my 5 worst work days, right? And that's exactly what the government tries to do to paint a picture. But in addition to indicting for controlled substance violations, they also decided to lump in, and this is something that sort of incites a little bit of rage between you and I, the impossible day theory, just to try to toss a little healthcare fraud in there and see if that would stick with the jury, Sean. So no investigation, no audit, no complete statistical analysis of his patients or his practice, no top-down view of it, no discussion with other doctors in the community, really no interview of patients. They only wanted to go with the evidence that they created and were really afraid that if they started asking too many questions, good things about Dr. Pompey would start streaming into the case.
So there were some really interesting facts about this case, right? So they got an initial indictment on Dr. Pompey, and if I'm not mistaken, they went back to the grand jury to seek additional indictments to get forfeitures, and they took his house at one point from him, his bank accounts. Is that correct in what I read in the indictments?
They were trying to take it. They didn't seize it, but it's very normal in these cases to have forfeiture allegations and try to take everything. And usually going back to the grand jury is just a process of cleaning the indictment up as opposed to really expanding the conduct.
Got it. So some other interesting allegations that came out, whether they're founded or unfounded, is that the investigator in this case, there's a history or a potential history. I'm going to use potential history of targeting certain types of individuals, whether they be of a certain age, ethnicity, whatever it may be. Is there some truth to that, or is that just a general statement?
Well, I don't know what information the person who had those allegations, what they have. I will tell you that there's only a few people who know more about this case than I do, and that would be the talented attorneys at Butzel Long who are on the case as well. And so the answer is I don't know, but I will say this. When it comes to DEA or even local prosecutions against physicians, I have noticed, and a lot of people out there in the space have also noticed, I think some people are trying to work on a study related to this, that the physicians who are targeted are generally either older physicians who are operating under an older model, maybe didn't update in compliance with the CDC guidelines, or they're minorities or foreign doctors. We have seen a significant uptick in minority physicians being prosecuted. I don't know why that is. I don't know if that's causation or correlation, but it does look very strange to me that when I look down my client list, most of my doctors are usually above the age of 65, and most of them are foreign, and many of them English is a second language. So at worst, they're not giving a doctor a little bit of grace for maybe coming from a different culture or having a language barrier or being a little older. I say at best. At worst, there's actual targeting of minorities.
I will say this. Prior to my testimony, I never met Dr. Pompey, never had an interview with him, never spoke to the gentleman. After my testimony, I had an opportunity to meet him in the attorney room that we had in the federal court building, and he just came across as one of the most sincere, genuine, kind people. And
Yeah.
one of the things that you said to me was, he's of Haitian descent, and I was born in South Florida, I grew up in South Florida, and there's a very large Haitian population in Miami, Fort Lauderdale, on the eastern, side of Florida. And I can say from my history of engaging with, the Haitian men, they are some of the nicest, genteel people I've ever met. What are your thoughts about Dr. Pompey? And then I wanna talk a little bit about the Substance Control Act part of this case, and then obviously we'll round out with the healthcare fraud, which I thought was just spectacular.
Yeah, can't wait to get into healthcare fraud with you, Sean, and maybe discuss a little bit about your testimony and why it was so impactful. But back to Dr. Pompey. So first, he was born in Haiti. I believe that his father was sort of ousted in conjunction with one of the former regimes. I may be getting that wrong, and I'm sure his brother will correct me there. But they had to flee, and they ultimately fled to Brooklyn, which is where Dr. Pompey spent some of his younger years. Not a great environment. I mean, his family probably didn't have a lot of resources, but he worked his way through school, ultimately getting to medical school. And while in medical school, he was actually mugged and shot in the arm and suffered some pretty severe nerve damage. Was a pain patient himself. Dr. Pompey's a very compassionate person, but I think that injury and seeing the type of healthcare that he required gave him a little bit more benefit of experience in going through that. But let's talk about Dr. Pompey's kindness, because in fact, after the trial, I mentioned this to him. I said, Dr. Pompey, the overall theme of the trial was love. I think people can understand that you love your patients and your patients love you. And regardless of how many, quibbles the government had with the way that you practiced, ultimately that became very apparent during the course of the trial. I've never seen this before in my entire career, Sean, but one witness, a government witness that they called, actually said, "I love this man," on the witness stand and pointed towards Dr. Pompey. Another witness, a government witness.
That's powerful.
Yeah. Another witness, a government witness, mouthed, "I love you," as she was walking off of the witness stand, passing Dr. Pompey to go through the court. I don't know if the jury saw that. That wasn't in response to a question and probably was improper, but it happened, right? And nobody provoked anything like that. And then the office manager, Diana Knight, who, along with you, were one of the most impactful witnesses of the trial. She actually, said, "I love Dr. Pompey," on the stand while crying. And here's where it got very interesting. During cross-examination of Diana Knight, I said, "Were you aware that the government has charged Dr. Pompey with prescribing 2 prescriptions to you?" She was receiving Adderall, and this is publicly in the case. She immediately broke down on the stand, tears, and she said, "I had no idea this was because of me." And it was just a powerful moment in the courtroom, very impactful testimony. But the reality is that these patients love Dr. Pompey. Early on in the case, when I was hired, we went down there to his practice to meet some of the patients. I was told that they could all show up and talk to me about the case. And I saw about 95 people that day and sat down and talked with them, along with a paralegal, and asked them about their experience. He's the savior. I mean, absolutely. And the fact that he was targeted was an absolute shame. So that's one of the reasons why Dr. Pompey has his freedom today, because he's a good man with a good heart, and the government couldn't really stain that too badly.
Quick question for you.
Mm-hmm.
If the government's going to call a witness and part of the charges against the defendant are from this witness, don't they have an obligation to notify that witness that they're calling that, some of these counts that we're prosecuting this individual on are based on his prescribing habits or treatment of you as a patient? Don't they have that obligation to disclose that?
No obligation. They can put anybody on the stand who's relevant and have them try to say whatever they want them to say. Now, it's sloppy. I can tell you, as a former prosecutor, I would never put a witness on the stand who was the basis for a criminal charge without knowing that was the case. Diana Knight should never have been called by the government. She was in the defense camp from day one. She was a friend of Dr. Pompey, loved Dr. Pompey, worked in the office. She was the biller. I think somewhere in the government's trial preparation, they said, well, if we don't call the biller, to testify, and we don't call a person who's related to these prescriptions, then there's going to be a little egg on our face. But the reality is that, you know, I'm aware they tried to prep her multiple times. She still wasn't in their camp, even after their efforts to prepare her. I say prepare, right? And she ultimately took the stand and just damaged their case heavily. It was very bizarre to watch. I never would have called her, but that's what happens. Those are the corners you back yourself into. This is like a Binger-esque moment for the prior trial of Rittenhouse, right? These are the things that you have to do when you back yourself into a corner and charge an innocent man with a crime, right? There's not going to be a lot of support there.
Didn't at one point, even though she was a government called witness, didn't she say, I'm in support of Dr. Pompey. I'm not a prosecutor's, you know, I'm not in the prosecutor's camp or something like that?
Yeah, so when one side calls a witness, they get to do a direct exam. Usually the questions are open, you know, tell us your name and what brought you here today, whatever, right? Then cross-examination, we get to ask very leading questions. Your name is Diana Knight. You were subpoenaed to testify here today, right? So I did a very long cross-examination of her, but elected to just kind of open her up and let her tell her story. And in redirect examination, the government, knowing that she just damaged their case, decided to cross-examine her. And what they wanted to do was try to make her look like a biased witness. And they said, well, you've said from the beginning, Diana Knight, you're not on Dr. Pompey's side, right? And she said, no, or not on the government side. She said, no, I'm not on your side. I'm on Dr. Pompey's side. And I think that Andrew Levency, one of the prosecutors in this case, I don't think he has a ton of trial experience. I think he was learning some lessons on the fly here. But I think that was some sort of attempt to make her look like a biased witness, but without any other evidence of bias other than the fact that she just happens to love the person who's, you know, charged in this case. It's not going to fly, and it didn't fly with the jury. They knew that Diana was telling the truth, and it was great testimony.
Yep. So Ruan, once again, Ruan played a significant role, I believe, in the acquittal of the indictments that were tied to Substance Control Act violations. Is that fair?
Well, one of the issues that we had in this case is that we didn't get a very strong jury instruction, which is why I was very nervous going into deliberations. I would have expected that Judge Murphy, given that Ruan was handed down, would allow some good faith language in the jury instruction, would beef up the mens rea requirement, the intent component in the jury instruction a bit. Unfortunately, Judge Murphy didn't do that and wrote probably one of the most government-sided post-Ruan jury instructions that I've seen to date. Now, I don't mean to fault Judge Murphy on that. His job is a difficult one here. The 11th Circuit just yesterday came out with their view of the Ruan case and clarified some things, but Judge Murphy didn't have the benefit of the 11th Circuit, the 6th Circuit, the 4th Circuit, or any other circuit reviewing these jury instructions. So he was operating, you know, kind of solo here and trying to craft something together, which is what the other courts have gone through as well. And he tried to make the best decision he possibly could. It just so happens, though, that instruction was not of the most friendliest that we've seen in other jurisdictions. We litigated the issue heavily. It would have been a major issue on appeal, but of course, the only finality we get in the legal system is when a jury reads not guilty on all counts. So what's done is done.
Right. Yeah. And I gotta tell you, this was my second time in front of Judge Murphy. I really like the guy. I think he's fantastic. He really is. He is very accommodating to the witnesses. He is very kind to the witnesses, and he's rather a funny, entertaining individual.
Yeah, I've got tremendous respect for Judge Murphy. Obviously, in the last year, I've spent probably 12 weeks or so with him and his staff.
Yeah.
In trial. Incredible staff. He's engaging. He runs the jury pretty tightly in terms of like when we're getting on and off the record, efficiently moves through a trial, and also lets you try the case the way that you need to. And for the federal criminal defense attorney, that's all I want from a trial judge. I I would try any case in front of him. Be very happy that at least he performed his job incredibly well.
Well, I knew he aggravated the prosecutor a little bit when he was trying to get his thoughts together, and he just popped off with, you know, how do you get an egg roll? And the prosecutor just kind of stood there and was perplexed. And, he said to him again, to the attorney that you were mentioning by name a moment ago, Andrew
Liebenstein, yeah.
Liebenstein. And he said to him again, counselor, how do you get an egg roll? And, he looked at me, he goes, you push it. I mean, the jury was laughing. I was laughing. I thought it was entertaining. I didn't think the prosecutor liked it, but since we're talking about the prosecutor, let's go ahead and get into the healthcare fraud aspect of this case, because to me, it was absolutely sensational. The mindset. And I don't know whether or not they actually believed what they were trying to convince the jury of, as opposed to, we backed ourselves into this corner, so we got to try to make this seem as complex as possible, and we have to try to, give our own interpretation as to what the guidelines are, what the rules are, etc. But can you talk about some of the indictment counts against Dr. Pompy from a healthcare fraud standpoint?
Yeah, Sean, and this is where I'm going to get a little spicy. Usually I'm pretty accommodating and understanding of a prosecutor's actions, and I believe that they're just doing a job. This is just downright reckless. I've got very real concerns about how that office is trained in the area of healthcare and their knowledge because of the stunts they keep pulling. So let's back up all the way to June, the Bothra case. They allege the impossible day theory. And for those listeners who don't know, evaluation and management codes 99211 through 5, in the code description has a portion that says typically X number of minutes. But in reality, we all know, and probably all of your listeners know, that these codes aren't billed based on time. Generally, they're billed on complexity unless there's a certain exception that applies. That is very clear. Everybody who is doing anything with coding and billing knows that to be a fact. Every expert the government would have talked to knows that to be a fact. And in fact, one of their billing witnesses knows it's a fact, because when I cross-examined her, she gave a carbon copy of your testimony related to time-based codes. She knows it too. Despite that fact, the government continues, at least this office, the Eastern District of Michigan, the healthcare fraud team, continues to allege that the impossible day theory can stand, and continues to try to add up the length, the amount of time for codes during a particular day and say that's over 24 hours and therefore somebody is committing healthcare fraud. Now, here's the crazy thing about this case, Sean. You would think that if you didn't have a lot of knowledge about healthcare, you would go to somebody like a Sean Weiss and you would say, hey, we're thinking of charging this guy with healthcare fraud based on this impossible day theory that we read about in some prosecutor's manual or something. What do you think about it? And that person would tell them, don't do that. That's not how any of that works, and don't charge him with that. Well, they don't do that. They don't have anybody other than Dr. Carl Christensen, who wasn't a biller, review these files and code them and try to determine if, based on the complexity of the visit, Dr. Pompey satisfied it. We had you as the ace in the hole here, because we had you review these charts and you very expertly testified that not only did he meet the level of coding required, but he exceeded it. So if the government did their homework prior to indicting, prior to putting this man in jeopardy, they would have known this to be true. If they did their homework after indictment by bringing these records to somebody, they would have known it to be true. And it took 6 years and a federal trial for them to actually learn this lesson about coding. And it's embarrassing. It's embarrassing that federal tax dollars were spent on this crazy venture. It's embarrassing that our federal prosecutors, who are in a healthcare fraud team, don't know enough about coding to understand that this is a crap theory, and that we have to educate 12 members of the public who don't know anything about coding on how bad this theory is in order to actually free a guy from fraud charges related to the impossible day theory. And I emphasize the word fraud because we're not charging him, or we're not alleging an overpayment here. We're not going through an audit and trying to pay back a little bit. They've charged him with a crime, with a 10-year potential sentence associated with it. living in a cage for this sort of conduct is what they were looking for. It's absolutely reckless, Sean. I can't say that strongly enough. They owe the public better. They need to do better.
Yeah, I agree with you. For me, so, anyone who knows me knows that, I don't take kindly to individuals who try to change what the guidelines are to benefit them one way or the other, right?
Yeah.
I've dealt with this when I worked on the prosecution side. I deal with it on the defense side. What aggravated me was the arrogance of the attorney who cross-examined me. And, he and this is where I think from more than 35 trials that I've done, I've learned to find that center, right?
Mhm.
If you remember the movie For the Love of the Game with Kevin Costner, every time he
Yeah.
goes out to the mound, he says, block the mechanism, right?
Yeah.
And what that means is block out the noise, block out the chaos, and focus on the task at hand. And
Mhm.
whenever and I know it sounds so corny, I don't literally say to myself, block the mechanism, but I put myself into a situation where I know that, look, my job is not to engage with counsel on cross-examination, right? Direct and cross-examination, it's an art as a witness, right? So for me, on direct examination, I want to be as engaging as I can. I want to be conversating with you, and people ask me, how much trial preparation do you go through getting ready for a criminal case? I mean, somebody's life is on the line.
Yeah.
And I tell them it depends on the attorney, right? Some
Yeah.
attorneys, I'm prepping for days,
Mhm.
weeks. With you, I asked you the weekend before I was coming up there, you want to do any trial prep? And you're like, nah, we're just
Nah.
going to have a conversation, right?
That's it.
I'm going to
Yep.
give you some questions. And that's what we did. And we had this incredible conversation. We opened up this dialogue, and between, conversating with you and looking at the jury and talking to them as if they were, getting educated for the very first time, hearing what this was really all about, taking
Yep.
something that the government tried to paint as this unbelievably complex, topic, and breaking it down to the most fundamental basics so that a 10-year-old could understand what we were talking about.
Yeah.
And the arrogance, where I was going with this, the arrogance on the prosecutor who cross-examined me. One of the things he said to me was, well, Mr. Weiss, didn't you use the term exceptional documentation?
Yeah.
Well, yes, I did. Well, how is it exceptional? Isn't it all cloned? And we'll get to the cloning part because
Yeah. Oh,
I think they just got destroyed on credibility, but
yeah. Yeah.
they didn't understand, to your point, counselor, they didn't understand that typical times under the 95 or 97 E&M guidelines
Mhm.
are irrelevant
Yep.
when it comes to the selection of a level of service, unless it's tied directly to counseling and or coordination of care. And they're like, but Mr. Weiss, doesn't it take time to do things? Well, yeah. I mean, it took you time to wake up this morning, take a shower, get dressed, get in your car, drive to the courthouse, open your briefcase, put your stuff on the desk. You don't charge for that stuff. We're not taking that into account for your billable service.
Yeah.
The same way with the doctor.
Yep.
Go ahead. I'm sorry.
Yeah, no, that's okay. So there's a lot to unpack there, Sean. But first and foremost, I have to say that, and this happened in this case as well, in the Bothra case. Watching somebody, the reason why we don't prepare a lot on direct, because watching somebody cross-examine you is like watching somebody who just got their first model rocket cross-examining Werner von Braun. I mean, you're not even in the same room at that point, right? You know healthcare. You also know how to teach healthcare, billing and coding to people very well because you've been doing it for a long time. Your trial prep is not the words that we utter before you go on stage. Your trial prep is your decades of knowledge and development of these issues, such that anybody who's taken a few months to even learn this stuff is not going to be on the same page with you. And so when you have the facts on your side and you have the knowledge on your side, there's really not much else we have to do other than say, hey, Sean, did you look at this? And what did you think about it? And let's teach the jury. You and I are having a collegial conversation at that point about, about what comes up. And my belief as a trial attorney is that too much preparation can be very bad with a witness like you, because I don't want you sitting there worrying about getting things out that we'd prepared to say. I wanted you relaxed. I wanted you comfortable, just like this conversation. We did no preparation. And I wanted you to be able to seamlessly move from one thing to the other. It works very well with a witness like you. Other witnesses, slightly different. We get the opportunity to talk to the jury after the case, and I won't disclose publicly what they said in order to protect, the information that they provided. But I will say this: every other person that I spoke to who was in the gallery, who observed your testimony or reviewed a transcript of it later, said that it was some of the most impactful testimony on the case. Now, the counts that you were testifying about were not the most serious Dr. Pompey was facing. But I've said this time and time again. It's on page 1 of the book. I don't have a copy, otherwise I'd flash it for you. It's on page 1 of the book. Trials are about credibility, right? And when you lose your credibility, you start losing other counts. That's the issue here. We knew on the healthcare fraud counts, we had them on the facts. We also knew that the jury is not going to forgive a government who pushes forward with these charges and wastes their valuable time on these charges when there's no basis for them whatsoever. So we needed to absolutely slam it home, and you did that. And then, one of the most impactful moments, I think, of your testimony was a little trap they tried to lay by showing portions of the medical record. And I don't mean to steal your thunder here, but portions of the medical record that look duplicated. You and I know that templated answers happens a lot. Doctors see the same thing many times. And they wanted to show that to you, Sean, to say, you were reviewing cookie cutter, auto, generated or copy and paste documents. And that's what you were saying was exceptional. The prosecutor, unfortunately, hastily made that play because what he didn't realize was that they weren't cookie cutter. When you actually put them up and put them next to each other, the two entries in the electronic medical record were different and had a couple of phrases that actually were very important to the understanding of the overall medical record. And once we showed that to you and we sat down, we knew at that point that at least on the healthcare fraud charges, they really had nothing left. And we think that it drastically impacted their credibility in the overall trial. And I'm just so thankful to have somebody that I can trust up there who knows their stuff. But also, Sean, somebody who understands, like you, somebody who understands the importance of credibility. If it's not there, you'll tell us in trial preparation. If something's bad, you'll tell us. So we went in there knowing that we had credibility on our side, knowing that we had the facts on our side, knowing that we had the full support of you on our side. And all we had to do was just get it out in front of the jury. And it worked. We ran the sheet, not guilty on all of them.
There were so many things, right? Things that I relived on my flight home. And, in thinking about our conversation today, right? And some of the most important facts that I think, and I would hope the prosecutors in especially the Eastern District of Michigan, I hope they listen to this podcast and I hope they learn from these things. A couple of things that came out during my testimony was that, look, when you're a subspecialist, you have general practitioners, right? Primary care, internists. Then you have specialists, right? Yep. Cardiology, orthopedics. Then you have subspecialists, right? And these are the uber subspecialized people. You take somebody like a Dr. Lesley Pompy, who is triple board certified, and this is a subspecialist. And you would expect to see higher levels of service because for somebody who's a subspecialist, that means for a patient to get to them, they've usually exhausted all of the traditional paths to getting better. And they're now having to seek out, in the case of a rheumatologist, right? A rheumatologist is a last ditch effort for a lot of patients, right? When they wind up getting diagnosed with lupus or psoriatic arthritis or whatever it may be, rheumatoid arthritis. Excuse me. So, we had to educate, the jury on, why I said that the levels of service billed actually
Yeah.
supported higher levels than what Dr. Pompey was paid. But the other thing, to your point that you brought up, and there were 2 points that I'll make real quick. One, he tried to be very slick and create a trap. And this is why you're so good at, what you do, which is you caught on very quickly. He put up the HPI, the history of present illness, right, for one date of service. And he said, "This is a date of service that you reviewed, right, Mr. Weiss?" And I said, I believe so. I mean, I looked at a lot of dates of service, but if you tell me that's what I looked at it. Yeah.
Yeah.
And then he quickly took it down, right? I think it was up for maybe 5 seconds, 10 seconds.
Yeah.
And then he put up another HPI. And he goes, "But this is not a date of service that you looked at." Okay. And then he took it down. He goes, "Now, were those both cloned? Weren't they identical?" And, and one of the things that you and I have talked about is, look, don't argue on every single point.
Yes.
Concede on the little things so that you don't come across as a pain in the butt to the jury, as argumentative, and then stand your ground on the things where you could definitively, poke holes in what they did. And you caught on to that and you redirected me and you forced them to put both of those back up side by side. And you could just see the air come out of the room for the prosecution when you did that.
Yeah, and I forced their paralegal to put them up side by side. It took her a minute, but I was like, no, you need to do this. I'm not doing it for you. Let's play a game here. So I don't want to get too much into the actual prosecutors trying the case, but there were a lot of tricks that were played that were just too cute, and that's one of them. When you're trying to pull the wool over the jury's eyes, or you think you've got this fantastic gotcha moment in court, those really need to be planned out and thought about before you try to execute something like that. Because if it blows up, that really, really hurts your case. The average federal prosecutor, I say this for the defendants who may be listening, or the counsel who may be listening, who are afraid to go in a courtroom. There seems to be this general census in federal court where a lot of people lose, right? Most of these cases don't go to trial. Many people are scared to go to trial because of the heightened federal sentencing guidelines associated with all this stuff. But just think about this. Most assistant U.S. attorneys try less than 2 cases a year. And most of those attorneys who are trying 2 cases a year are trying cases that are, a couple of days long, maybe a week, maybe a little longer. But the number of people who have trial experience getting into trial for an entire month and who have done it repeatedly for the course of their career is very limited. Now, Wayne Pratt, the other prosecutor on the case, was he's been a mainstay at that office and is very talented and knowledgeable. He's got a very folksy approach and he does a great job. I remember when I was much younger, sitting in the back of the courtroom, just observing and learning how this process worked. I had a lot of respect for Wayne when I would see him up there and think, oh man, going against that guy would be really, really tough. Now it's very interesting that we were finally able to get, a great verdict against him. But I have absolutely a ton of respect for Wayne Pratt and what he does. But the new crop of prosecutors are not Wayne Pratt's, and Andrew Levensey had a big part of this case, and he didn't carry it very well. The new crop of prosecutors, largely comes from large law firms where they did some doc review and maybe helped out a partner, but weren't really getting into the courtroom. And then very quickly, they're given a course and expected to go into the courtroom and knock heads. And you need years of practice of being able to do this before you can do that. I came up in a very different way. I prosecuted cases in the Marine Corps where sometimes I had a couple of trials a week. I did administrative cases. To get my healthcare knowledge up, I did licensing and board cases. And now I just have a steady stream of trials. And, I'm getting more and more experience, every time I go up there, I try to learn valuable lessons. So I say all that in a very long-winded way to say this. If you're scared about going up against a federal prosecutor in court, just understand that while there are many very experienced, knowledgeable federal prosecutors out there, the current class of prosecutors that are coming up do not get the benefit of dedicated healthcare knowledge, generally speaking, do not have a ton of trial experience. And these cases, unlike many others, are largely agent-driven because the agents usually have a little bit more understanding of healthcare, especially if they're OIG, than other folks. There's an edge that you can get as a defense counsel as a result of those factors all mixing together.
And it's so interesting that you brought that up because yesterday I shared your post that your firm put out there about the case.
Yeah.
And one of the attorneys said to me yesterday, she actually forwarded, because she does civil, she forwarded it on to the partners in the criminal division. And she said, see, you can actually win these cases. She literally said that to me on the phone yesterday.
Yeah.
And she's a talented lawyer. The last trap that the prosecutor tried to set for me, and I think this was a terrible one, you know, was, and that's what he closed with, and it just didn't work, was, so Mr. Weiss, can you, for the jury, just confirm for us that just because, and I want to be clear here, what you're saying, just because something is documented in the medical record, that means it happened? And my response was, well, it doesn't mean it didn't happen.
I loved it. It was great. I think you actually got a couple of members of the jury to chuckle at that quick response. I mean, Sean, you're witty, and it comes off on the stand, and that was a fantastic moment. You did.
Well, I have 5 grandbabies, 3 kids, and a wife who challenged me every step of the way, every single day. So I got to keep my wits a little bit sharper. But
forged in the fire.
I will tell you, forged in fire. I will tell you, and for our listeners, you know, especially those of you who, and I have a lot of attorneys who listen to this show. If you are a criminal defense attorney and you hesitate to go to court, your hesitation shouldn't be based on whether or not you think you could prevail in the case. Put that to the side and seek out co-counsel. I know Ron has been co-counsel on a number of these high-profile cases. Seek out witnesses who have extensive experience, not just working as defense experts, but those who actually have worked both sides, so that there's no ability for one side or the other to say, well, aren't you just a hired gun for the prosecution? Or aren't you just a hired gun for defense counsel? When you find experts who are not only able to consult with you to help you understand where the problems exist in the defense or on the prosecution side, but they can take the stand and they can engage in a meaningful discussion and build credibility with a jury of their peers. That's how you win cases, at least from my perspective, over 20 some odd years of being blessed to work on these kind of engagements.
Exactly, Sean. And the path to success in a case does not start in the courtroom. It starts way before that. It starts pre-indictment, during investigation. It starts with negotiation to try to whittle down some of those charges. It starts with a robust internal investigation to get all of the facts as early on as possible so that you have a monopoly of information. You know, I talk about this in Unraveling, you know, Federal Criminal Investigations, the book. You can find it on Amazon if you're interested. But I go through this quite extensively. A lot of attorneys think that they can just review government discovery, what the government hands you, talk to your client, prepare a defense. They don't start looking for experts until they get closer to trial. All of that stuff needs to be done up front. Don't trust the government's evidence. Go and do your internal investigation. Get somebody good to interview witnesses. Get that data to Sean Weiss or Dr. Murphy, who's, you know, our pain management expert, Dr. Todd Hess, who also works with CCG, great pain management expert. Get it to them, work with them, build up the case, then make a trial decision. I send every one of my clients who's facing a difficult trial decision a trial memo where I break down our investigation, the government's evidence, the statutory offenses so that they can sit down and decide. It's not my decision if a case goes to trial. It's a client's decision fueled by information. And if you don't get the right information for your client and help them make an informed decision based on the real facts, not the government's version of them, then you're doing them a disservice. And the last thing I'll say is attorneys who sit down and review government witness statements and gain opinions about their client and their conduct based on those government witness statements are going in the wrong direction. In every single one of these cases, including this case, I found issues with those statements that could at best be described as an agent sort of flavoring things his own way or her own way, but at worst be described as outright misrepresentations. We showed those statements to every one of the witnesses that we interviewed, and there were a lot of problems with them. You can't trust them. You got to go out and get your own information and prepare these cases. So if you want success, that's where you find it. Unraveling Federal Criminal Investigations is sort of a guide at every one of those stages where you can see how it's done and check it out. And hopefully you'll be able to learn maybe a different way of doing things.
Yeah, and if you want to give me a link to that book, as well as your other book, Fight the Feds, I'll make sure that I post those in the description of this episode for all of our viewers and listeners so that they can go out and get a copy of these books. I've read Ron's recent book, which is Fight the Feds. You could also subscribe to his newsletter that he has, which is fantastic because you always get some great perspective from a world-class criminal trial attorney, and you're getting insights from somebody who's in the trenches on a weekly basis. I know we have I think 2 or 3 more criminal trials coming up in 2023. You and I this year. You're going to be down here in my neck of the woods in May. I'm excited about that for 5 weeks. So looking forward to hosting you and your family down here. It'll be a great time of the year to be in South Georgia.
Yeah, can't wait, and we certainly appreciate your hospitality there. Back to the blog. If you go to Federal Defense Blog, and Sean, I'll send you the link there. I try to update it as regularly as I can with just some of the most recent updates, and there is a bit more of a discussion about this trial. But sort of as we're wrapping up and getting to the end, your work on this case was phenomenal. We couldn't have gotten here without you. There's a few other people that I want to mention just so that people understand that this isn't just one man going up there and getting victory for a client. It's a team. So let me just go through that to make sure that they're recognized as well. We've got George Danini of Butzel Long, which is a large Michigan law firm. He was there with Dr. Pompy during the raid and tried to break in and make sure he was represented, and has been on this case day one and is a fantastic attorney and now a friend. He did a wonderful job in the case. Joe Rashat is also somebody who works at Butzel Long and works with George. Joe is at trial sometimes, but not all the time. But Joe is in the background preparing the most amazing stuff, including closing slides, which were just a beautiful work of art. I know George worked on those as well. We've also got the CCG healthcare team, Stephanie Marquise, Mark Caudle, Mike Staples, all of those folks banded together to do the right work that we needed. And then my staff at Chapman Law Group did a fantastic job. We've got Stephanie Angelo, and she's my legal assistant. She does a fantastic job, and my paralegal, John. So just wanted to thank those people and know that make sure your listeners know that there's a team that's required to do the heavy lifting in these cases. It's not easy, but when the team's able to band together like you and I and some of the other people on the case, we can really do good work for clients. And Dr. Pompey's free today, which is it just sort of warms my heart.
Yep. Two full trial acquittals in a row. One in excess of $450 million with 54 indictments against 4 physicians. Now this one with Dr. Lesley Pompy, 38 indictments against this individual. Counselor, to you and your team, congratulations. And I do agree with you. It is a team lift. This is a heavy lift. The work that your investigative team did in preparing the charts for my review to make it a seamless transition so that I really had great evidence in front of me so that I could do what I needed to do on the stand. You can't substitute for quality individuals, and that's what
Yeah.
CCG and Chapman Law Group bring to the table. So
Yeah.
well done, and congratulations to you and the entire team at your law firm, the other law firm, and to CCG staff as well. All right, that's going to conclude this episode.
Sean, one more thing.
Yeah, please.
I know we may be running out of time, but I have a little bit of good news to share with you that I didn't want to pop on you earlier. I wanted to do it while we're live on the air. But there was a little old case that you were involved in where you were going to get a chance to spend some time in Puerto Rico with me. That case was set for trial on January 14th. A federal judge decided to exclude you as a witness because you were going to testify that you needed a Medicare reassignment of benefits in order for a hospital to bill in your name, right? You were improperly excluded. Well, a motion has just been filed by the government to dismiss the counts in that case, which means there's not going to be any trial on January 14th and not be any conviction of this particular provider. I imagine it is in large part due to the fact that even though the judge excluded you, the government in the back of their head knew that that issue would be tried on appeal and that you really did need a reassignment of benefits. So another victory for you, Sean, another victory for us, and that's 3 in a row. And so I'm just going to take my wife to Belize. So if anybody has any recommendations for what to do there, no more Puerto Rico.
I actually have a very good friend, Abel Gonzalez, who's from Belize. Yeah. I will get you some places where you need to go and spend some time. Counselor, congratulations. That's 3 in a row, man. That's incredible. That's impressive.
3 in a row. Yeah.
All right, everybody, that's going to wrap up the Compliance Guy episode for this week. I can't tell you how much I appreciate each and every single one of y'all hanging out with us, tuning in, logging on, and spending time with myself. To Ron Chapman, to the Chapman Law Group, to CCG, his consulting arm, where they do all the investigations on these Substance Control Act violation cases and these healthcare fraud examinations. Congratulations again to your co-counsel. Folks, we'll be back next week on Monday with a brand new coding and compliance roundtable. But here's the other fun thing. We'll be back a week from this Friday with our first legal roundtable. And Ron Chapman is a part of that with a couple of other extremely talented attorneys. I can't wait to put that information out next week and get you all ramped up for that. So until then, remember, be good to yourself, but more importantly, be good to each other. Take care.